So, do we have a massive victory for our Second Amendment rights coming very soon here in New Jersey?
New Jersey's new law prohibiting the public from carrying concealed guns in certain sensitive areas suffered another setback today.
There's a restriction on open carrying during a state of emergency. There's a restriction on open carrying anytime you get inside a vehicle.
Gun rights advocates in New Jersey are headed back to federal court to once again fight a state law that bans concealed carry of guns, where a gun bill designed to limit concealed carry in New Jersey went from the fast track to getting pulled last month.
But today, a federal judge ordering New Jersey not to enforce the tight restrictions of the law.
The question of where Americans can legally carry firearms is about to be decided by judges examining laws written before electricity existed. Right now, a federal court in Philadelphia is wrestling with a case that could either expand or dramatically restrict gun rights across multiple states. And the entire debate hinges on how we interpret regulations from the 1700s and 1800s. This is not just another gun control story. What happens in this courtroom could determine whether you can carry a firearm into a hospital, a park, a beach, or even public transportation. The stakes are enormous, and the legal reasoning being used is unlike anything we have seen in modern constitutional law. So what exactly is happening here, and why should everyone, regardless of where they stand on gun rights, be paying close attention? Let us break this down from the beginning. New Jersey passed a law that bans carrying firearms into what the state calls sensitive places. We are talking about schools, public transit systems, beaches, stadiums, hospitals, and parks. The state argues these locations require special protection because of the number of people gathered there and the potential for catastrophic harm if firearms are present. But gun rights advocates and firearm owners in New Jersey are fighting back hard. They have taken this case all the way to the Third Circuit Court of Appeals, and they are asking the full court to declare these broad, sensitive places restrictions unconstitutional. If they win, residents with legal carry permits could bring firearms into a much wider array of crowded public spaces. Here is where things get fascinating from a legal perspective. The entire case turns on a Supreme Court decision from 2022 called New York State Rifle and Pistol Association versus Bruen. This ruling fundamentally changed how courts must evaluate gun regulations. Before Bruen, judges could balance public safety concerns against Second Amendment rights. They could look at statistics, consider modern circumstances, and make practical judgments about whether a gun restriction made sense. That approach is now off the table.
It's now back in front of the Assembly, where lawmakers are considering the constitutionality of some of the language that's since been refined.
Very confusing, almost purposely so, to make it extremely difficult for law-abiding citizens to exercise their Second Amendment rights.
You can't open carry in a city of the first class without a valid or recognized license to carry or reciprocated permit.
Sensitive places, including parks, beaches, bars, casinos, and more.
New Jersey lawmakers are introducing some of the harshest gun carry laws in the country.
Sensitive places are on the chopping block this week in the Third Circuit, and the state is in major defense mode.
Like the definition of a weapon and more specifics around so-called sensitive places where guns would be prohibited.
Under the Bruen framework, courts must look backward in time. A gun regulation today is only constitutional if it matches the historical tradition of firearm regulation in America. Judges cannot simply decide that a law is reasonable or serves public safety. They have to find analogous regulations from the founding era or the period shortly after. Now here's the part most people miss, and it is the key to understanding this entire case. During oral arguments in Philadelphia this week, several judges pushed hard on a critical question. Should courts emphasize gun regulation traditions from the nation's founding in the late 1700s? Or should they look at laws from the Civil War era and Reconstruction period in the 1860s and 1870s? This might sound like an academic distinction, but it changes everything. If courts focus primarily on founding era regulations, gun rights advocates win big. America in the 1790s had almost no restrictions on where people could carry firearms. There were no massive stadiums, no subway systems, no modern hospitals. The few restrictions that existed applied to narrow circumstances, like bringing weapons into legislative chambers or courthouses. But if courts can draw from Civil War era regulations, New Jersey's case gets much stronger. After the Civil War, Southern states passed sweeping weapons laws, partly to disarm formerly enslaved people, and Western territories like Dodge City and Tombstone famously banned firearms within town limits. These historical examples give the state far more ammunition, no pun intended, to justify modern sensitive places restrictions. So which era controls the outcome? That is the million-dollar question the Third Circuit has to answer. Gun rights advocates arguing before the court made their position clear. They believe the founding era should carry the most weight because the Second Amendment was ratified in 1791, and its meaning should be anchored to that period. In their view, the state cannot simply declare vast categories of public spaces off limits to lawful gun owners by pointing to Reconstruction-era laws that were often motivated by racial discrimination, rather than genuine public safety. The state of New Jersey fires back with a different argument. They point out that the 14th Amendment, ratified in 1868, is what actually applies the Second Amendment to state governments. Since the 14th Amendment comes from the Reconstruction era, regulations from that period should carry equal or even greater weight than founding-era laws. This is a genuinely brilliant legal chess match, and the judges seem to recognize how much rides on their answer. But let me show you why this matters beyond the courtroom, because the practical consequences are staggering. Right now, New Jersey's law covers an enormous amount of public space. Think about what counts as a park, a beach, or public transit in a densely populated state like New Jersey. If you add up every bus route, every train station, every public park and beach, you are effectively banning firearms from a huge percentage of the places where residents actually spend their time. Gun owners argue this turns their constitutional right into a theoretical one. Sure, you can technically carry a firearm, but the list of prohibited places is so long that in practice, you cannot go anywhere with it. That is not what the Second Amendment protects, they say. On the other side, consider what it means to allow firearms in places like hospitals. Emergency rooms are already some of the most volatile environments in America. Nurses and doctors report being assaulted at alarming rates. Introducing legally carried firearms into that environment raises serious questions about patient and staff safety. The same logic applies to public transit. New Jersey Transit carries hundreds of thousands of riders daily. Allowing firearms on crowded trains and buses introduces risks that simply did not exist when the founders were writing the Bill of Rights. Several judges during the oral argument seemed genuinely torn about how to navigate these concerns. Some appeared sympathetic to the gun rights arguments, questioning whether New Jersey's law sweeps too broadly. Others seemed concerned about the real-world implications of striking down restrictions in sensitive locations. What makes this case even more significant is its reach. The Third Circuit covers Delaware, New Jersey, Pennsylvania, and the Virgin Islands. A ruling here will directly affect gun laws across all these jurisdictions, but the implications extend further. Other federal circuits are grappling with similar questions, and they are reaching contradictory conclusions. The Fourth Circuit recently upheld Maryland's assault weapons ban using a different historical analysis. The Fifth Circuit has taken a much more expansive view of gun rights. The Ninth Circuit is dealing with challenges to California's restrictions. When federal appeals courts disagree on constitutional interpretation, the Supreme Court typically steps in to resolve the conflict. This New Jersey case could very well end up back before the justices who decided Bruen, giving them an opportunity to clarify exactly how this historical framework should work. And that brings us to the biggest question nobody is talking about enough. The Bruen framework asks judges to be historians, but judges are not historians. They are being asked to sift through centuries of colonial statutes, state constitutions, territorial codes, and local ordinances, many of which are incomplete, contradictory, or poorly documented. Professional historians who have filed briefs in these cases often reach opposite conclusions from the same evidence. In one recent case, two expert historians looked at the same set of colonial-era laws and came to entirely different conclusions about whether they supported a particular modern regulation. If trained historians cannot agree, how are judges supposed to reach consistent results? This is not a theoretical problem. It is already happening. Since Bruen was decided, federal courts have issued wildly inconsistent rulings on similar gun laws, with each judge selecting different historical sources and drawing different conclusions. The result is a patchwork of contradictory decisions that leaves gun owners, lawmakers, and law enforcement unsure about what the law actually requires. For gun rights supporters, this New Jersey case represents an opportunity to push Second Amendment protections further than ever before. A ruling against the sensitive places law would limit the government's ability to carve out gun-free zones and could set a precedent that forces other states to roll back similar restrictions. For gun control advocates, the consequences of losing are severe. If courts strike down sensitive places restrictions, states will have far fewer tools to regulate firearms in public spaces. Every new gun regulation would need to survive a historical analysis that is inherently subjective, making it extremely difficult to pass laws that address modern public safety challenges. One thing is certain, whatever the Third Circuit decides, this case will not end the debate. Gun rights litigation has exploded since the Bruen decision, with challenges to regulations across the country. Courts are being asked to evaluate laws governing everything from assault weapons bans to age restrictions to concealed carry requirements, all through the lens of historical tradition. We are in the early stages of a fundamental reshaping of Second Amendment law, and the New Jersey sensitive places case is one of the most important battles in this broader conflict. The court has not indicated when it will issue its ruling, but legal observers expect a decision within the coming months. When it comes, the impact will extend far beyond the Garden State. For now, gun owners, lawmakers, and advocates on all sides are watching Philadelphia closely, waiting to see how 18th and 19th century regulations will shape the rules for 21st century public spaces. The outcome will tell us a great deal about where Second Amendment law is heading, and whether the courts can make a 200-year-old historical framework work for a country the founders would barely recognize. That's it for today, folks. See you in the next video.